Good evening and welcome to the August 2016 Richardson Law Office's Legal Hangout. I'm Steve Richardson, and this month we have hopefully a very informative and interesting topic. We're going to talk about wills here in the state of New Jersey and why you need a will, along with a living will and a power of attorney. We're going to talk about the difference between a regular will and a living will, and powers of attorney and why you need them, and what can happen if you don't have one. Now, I'd like to thank Ruth, one of my viewers on the Hangouts, and also one of the subscribers to my newsletter. I had requested some input this past month in my newsletter on topics for this month's Hangout. Ruth came up with a great topic of wills, why you need a will, and what's the difference between a will and a living will. So we're going to get into that topic this evening. Now, again, just as a disclaimer, we are here in the state of New Jersey, although with the power of the internet, this could be viewed anywhere in the world. So just be aware that when I talk about the legal issues surrounding these documents, I'm talking about New Jersey law. I'll touch very briefly on federal law with regard to taxes, but other than that, we're talking about New Jersey law. So if you're viewing from another state, just take it with a very good big grain of salt. It's just general information, and you're going to want to talk to an attorney in your state, so just New Jersey. All right, let's talk about the three documents that we're going to discuss and what they are. First is a will. Fairly obvious. Everyone knows what a will is. It's just a document that sets forth your instructions on what you want done with your stuff when you die. That's what it comes down to. I want this person to take my stuff and dispose of it in the following manner. And that, at its very essence, is what a will is. It means nothing until you actually die. It's just a piece of paper. It has no power. It can be typewritten. It can be handwritten. The handwritten will is called a holographic will here in New Jersey. All of the key terms of a will must be in your handwriting, must be signed by you, so there's at least a way of verifying handwriting. I would really recommend that if you're going to have a will, do it properly with witnesses and everything, but they can be handwritten or a more formal document. You can go to an office supply store and get forms. You probably download them off the internet as well. Just be sure that they are certified to work in New Jersey. Laws are fairly the same from state to state. We just want to make sure that if you're putting together a will, that you'll be able to probate it when it's all said and done. Now, that's a will. What's a living will? Well, I just said a will is just a piece of paper till you die. A living will is essentially a document that sets forth who you want to make medical decisions for. If you're unable to make a decision, you're unconscious, you're in a coma, you have suffered some sort of neurological injury or disease that puts you out of your right mind, you're not competent to make these decisions, and they need to talk to someone else, who do they talk to? And that is your proxy under a living will. You have that living will. Just make sure that whoever your proxy is can put their hands on a copy so that they can produce it. Or if you go into the hospital for a procedure, whatever, make sure that the hospital has a copy of your living will and that it's made part of your chart. And so that is a very great comfort, especially some of the decisions that may have to be made with a living will, having those instructions. That's what a living will is. Now, a power of attorney is the third type of document. That is a document that is good up until death. It becomes worthless upon your death. As much as a will has worth after your death, a power of attorney expires and becomes worthless once you expire. But it's a good thing to have in the event that you can no longer handle your own affairs. General, what's called durable power of attorney. is one that survives the disability, right? And it's sometimes referred to as a springing power of attorney because it can become effective upon your becoming disabled. And what disability is and how that's determined can be set forth in the power of attorney. So, and that power of attorney, that person becomes you, in effect. Attorney, basically the word means one who represents another. You become an attorney in fact, as opposed to an attorney at law, which I am. A power of attorney, you have the power of someone who stands in the stead of someone else, or you. So that's the three documents we're going to be talking about. And I want to go over with you tonight why you should have these documents, why they're important. First, let's talk about a will. A lot of people think, well, you know, I'm married, and you know, everything's going to go to my spouse anyway upon my death, and even if my spouse predeceases me, then everything will go to the kids anyway, and I really don't need a will. Well, I would disagree. There are some problems that can come up if you don't have a will as a married person, and even if you don't have children. So let me give you some examples of the problems that can arise as a result of not having a will. Now, if you are married and you have children, and the children are all your children are the children of your spouse as well as you. Okay. Then, if you die, then your spouse gets everything. Then if your spouse should predecease you, then it would go to your children. So in that sense of where the money goes, if that's all you want, yes, but that's not always the case. And there are certain circumstances in which the surviving spouse may not get anything. What if this is a second marriage for you or your spouse? Let's say your spouse is a widow, and she had children from a previous marriage, or she's divorced but has children from a previous marriage. Well, that can become a complication because they're not your children. Should you die and you have some, say your spouse dies, and she has some children from a previous marriage, and they're not your children. Well, under what's called intestate succession, which is a fancy name for the law in New Jersey of who gets what if you die without a will. If you die leaving no instructions, then the default is you go to the statute and statute. You know, the New Jersey gets to say who gets what. And your surviving spouse, under those circumstances, is not going to get everything. What happens is the surviving spouse, you receive the first 25%, but you get at least $50,000 from the state, and 25%, but no more than $200,000, and then plus 1/2 of the balance, and then the children would receive all the other assets. So it's a bit of a calculation there, but the point is that don't assume that in that circumstance where your spouse has children from another marriage that you will get everything if they die. Or if you die and you have children from a previous marriage, don't assume your spouse will get everything. So you need to be clear and have a will in those circumstances. Now, supposing you're married, first marriage for both of you, but you don't have any children, and your parents are still alive. On that instance, again, surviving spouse receives 25%, same thing, at least $50,000, but no more than $200,000, plus 1/2 of the balance, and then the decedent's parents get the rest of it. So it may not all go to you. So don't assume that if without a will, you die, your spouse will get everything. There are circumstances where that may not happen. So that's that. Now, you have minor children. what happens if your you and your spouse die together in a car crash or a plane crash or some other problem where you die within a short period of time of one another, where the surviving spouse doesn't have a chance to make other plans? Who takes care of your children? You have minor children. You're both now gone. A will gives you the opportunity to name a guardian, to make arrangements. Talk to this person. Have a guardian. Make arrangements for your minor children should you die before they reach adulthood, so that someone to take care of them. And if they're minors and you both die, well, as you said, the children would inherit. But you want a 5-year-old to inherit your entire estate? Or would you rather have that money put into trust, maybe for a college fund or just the cost to raise that child, put into trust and name a trustee, someone that can look after that money and tend to it? Usually the trustee is also the guardian of the child. But you need to make these arrangements just in case you die before your children reach the age of majority. Also, without a will, there's no clear choice or determination of who is to administer your estate. In a will, you say, this person's going to be my executor, and if they can't handle it, then I have an alternate for this person. Fine, you have the ability to choose it, and usually it'll be your surviving spouse. And if you have an alternate, but you have control over that, you can dictate that. If there's no will, then an administrator must be appointed by the surrogate court here in New Jersey. Now, the surviving spouse has first shot at it. If there is a surviving spouse, they can tell the surviving spouse, I want to administer the estate of my spouse, my deceased spouse. Okay, that's first choice. But again, if you don't want to leave that up to chance, just be sure of it. Have a will, name a successor, name an executor for that will. Now, if you don't have a will, also there can be additional expense for the estate. Usually in wills that I draft, I ask you, do you really trust this person to handle the money, to be responsible living, and you should choose a responsible person to be an executor. But usually you can say in your will, and that executor can serve without a bond. Now, if there's no will, that's not a determination. Now you go into surrogate court and say, I'm the surviving spouse, I want to be administer this estate. Well, you may have to post a bond, which means there has to be some sort of valuation of the estate, so you know how much the bond should be for, and then there's a bond premium that'll be an annual cost until the entire estate is resolved. So that can be an additional expense, both the expense of any kind of appraisal that may have to be done to determine the amount of the bond, and of course the premium on the bond itself. And of course, if your estate is large enough, then there may be some tax consequences. A will allows you to do some tax planning, some estate tax planning, to minimize the amount of taxes and therefore maximize the amount of money or assets that your heirs will receive. If you don't have a will, you can't do that planning. So especially if you have a significant amount of assets, you do not want to die without a will. You want to talk to someone who really knows something about estate planning. You also don't have the ability to make specific bequests. Having in an intestate estate, someone who dies without a will, then you pretty much resolve everything by selling all of the assets and distributing the money. Or if it's just a surviving spouse, it would go to surviving spouse. The title just goes by operation of law. But again, you don't have the ability, if you want some particular item, an heirloom in your family that you want a particular relative to have, certainly your spouse would get most of the estate in most cases. But what if there are particular items that you want particular people to have, and you want to carve that out? Well, the will gives you the opportunity to do that. You want to have that ability. And also, if your will is there in a set of instructions, your intent is clear on who gets what, and it can minimize the chances of there being some disputes. And in addition, maybe you don't want someone to inherit. Now, you can't completely disinherit your spouse. As long as they're your spouse, they're entitled to at least a third of your estate. It's called an elective share. So you just want to make sure that you can't completely disinherit them. You can maybe limit what they inherit, but they get at least a 1/3 share. But you can disinherit children. I've had situations in which a will would say, I specifically do not provide for my son, Joe, because I believe I provided for him sufficiently during my lifetime. And that's it. Joe can't come in and say, oh, Mom forgot to mention me. This is what a terrible mistake. I'm sure she would want me to have a share of the estate. Nope. It's clearly in the will that she was not making provision for Joe. So that's there. So a lot of reasons why you would want to have a will. Now, what about a power of attorney? We're talking about wills. Why should you have a power of attorney? And people often come into me wanting a will, and I'll say, well, you really need more than a will. You need all three of them. You need the triumvirate: will, power of attorney, and a living will. They can do with less, just have the will they want, but that's what I recommend. So what if you don't have a power of attorney? Well, that can run into problems if you become disabled, either on a temporary or permanent basis. Who pays your bills? Who has that ability? Now, if you have a joint checking account with your spouse, then your spouse can write checks and pay bills. And if you own your home and everything that is titled is clearly entitled to both of you, then your spouse may be able to make certain decisions. But if you are not married, or you're a widow or whatever, and you don't have that person in your life, then you're going to need to make other arrangements. And even if you have a checking account that is joint with one of your children, for example, so that they can write checks, that isn't going to resolve all the issues. Maybe you're permanently disabled. Maybe you slip into dementia and get Alzheimer's, or in a coma, or some such thing. Something long term, and you have to sell your house. Well, with a power of attorney, someone with a power of attorney can do that. Can take care of these things. Can make other decisions because they are you. They have the power of being you. They're standing in your shoes. So, like I said, you can dispose of other assets like real estate, extra time and expense. Now, if you don't have a power of attorney and you slip into dementia, or you're in a coma, this and the other thing, then your spouse or your children would have to go to circuit court, go to chancery court, and request a guardianship. Say this person is in a coma, this person has Alzheimer's, they're really in no condition to handle their own affairs, and I want to be the responsible person to handle it for them. Well, that costs money in legal fees and costs of examining doctors to produce reports. And of course, time goes by while you're waiting for all of this to happen. But if you have a power of attorney that says this person is disabled, I now have a power of attorney, and you immediately step in and take care of business. So you avoid that. And also other important life decisions can be made. Maybe you need to make contributions to an IRA or disperse from an IRA, or things like that, from a pension. Other financial decisions that need to be made that you can make. And a power of attorney simply allows you to do that. So it's an important document. A living will. What can happen if you don't have a living will? Well, what if you end up in a permanent vegetative state? You're pretty much in a coma. It's determined you're not coming out of it, or you are going to die eventually. You're never going to regain consciousness. This allows you to give decisions on what kind of care you want. It's a very difficult decisions. How much effort do you want your doctors to go to keep you alive? Some people say, I don't want any extraordinary measures. Okay, just let me die. Well, having that set forth in a living will, that clears up and simplifies a lot of things because it's on record. You have a proxy that can come forward and say, I am this person's medical representative. They have indicated they do not want to be kept alive. Pull the plug. Not an easy decision to make, and I'm not trying to make light of it, but it's certainly easier to do. If you're in that situation, there is no living will. Now you're back in court, like I said, with a guardianship, and you're on a right to die issue. And the judge is hearing testimony from witnesses on what Aunt Mabel would want. She wouldn't want to be kept alive. She wanted to let go and be allowed to die. And then a judge has to make that decision. And again, further delays. So it's good to have a living will for that. And even with, other than pulling the plug and end-of-life decisions, just having some guidance to the person on what kind of treatment decisions you want made, what you prefer, makes it easier for that person to carry out your wishes. And sometimes it can lead to a delay in treatment. You're not conscious, there's a problem, and you need someone to make a decision. You have someone that's there that can be aware, that can make that decision, so that helps. As I said earlier, you go into the hospital, whatever you do, just make sure that the hospital has, and your treating physician, your regular treating physician, make sure he or she has a copy of your living will. So if maybe you rush to the hospital emergency room and you notify a treating physician, they'll have the living will on file and be able to contact the proxy. So it makes life a lot easier. Finally, I just want to talk briefly about some tax issues that come up. I'm not a tax attorney. I'm not an estate planning attorney. So I'm just giving you food for thought on when you should start being concerned about tax planning for your estate. Is your estate big enough that there might be tax consequences where you might want to make some tax planning and have a will that has tax planning in it? Now, there are both state and federal estate tax laws. So you need to be aware of both of them. Federal government basically levies taxes on larger estates. If you have, it's called a unified exemption for estate and gift tax. And as of 2016, this year, as I'm making the video, the federal maximum is $5,450,000. So is your estate, all told, including benefits from life insurance policies and everything, is it under 5.45 million? You sure? Most people pretty sure their estate is not worth more than $5-6 million. But that's where it is from a federal standpoint, where that taxes can kick in, and where you might need some sophisticated estate planning. State of New Jersey, good old New Jersey and taxes. We don't have just one, we have two types of taxes that come into place upon death. There's inheritance tax and there's estate tax. Two different taxes. Now, and they tax on a different basis. Inheritance tax is based on who inherits. Okay, so there's no inheritance tax if your children or grandchildren, parents, are inheriting. But the further afield you go, aunts, uncles, cousins, etc., or total strangers, can be in a class of beneficiary in which inheritance tax is levied. And it's on a sliding scale depending upon how much that person stands to inherit and what percentage of that needs to be paid in inheritance taxes. So that's inheritance taxes. Estate taxes in New Jersey is not who inherits, but how much is inherited. Just like the federal taxes at $5.45 million. When the federal government was increasing that ceiling, it started going up and up and up, New Jersey decided to unhook from the federal guidelines. Used to be they were the same. And New Jersey said, we don't want to go that high. So right now, in 2016, the estate tax, New Jersey estate tax maximum is $675,000. Okay. So obviously that's going to scoop up and be relevant to much smaller states. So you might want to take a closer look at it to find out if you need this type of estate planning from a state estate tax standpoint. And you're going to want to talk to an estate planning professional. So that is it for this month's Hangout on why you need a will, living will, and power of attorney. I hope I've answered your questions or any questions you may have on this topic. Our next Hangout is going to be on September 22nd at 5 p.m. And it's going to be part 2, a follow-up to this topic. This month I talked about why you need a will, living will, power of attorney. And you decide, okay, Steve, I got you. I need to have these documents. What is it I need to think about? What do I need to start planning for to put these documents together? What are the important questions that you need to ask yourself? So next month, September 22nd, 5 p.m., we're going to talk about what you need to get together and what you need to consider to have a will, or what you need to bring with you to talk to an attorney, because the attorney's going to ask you these questions for what you want to do with your will. So that's it for this month. If you like this video and you find it informative, I'd appreciate if you would click that thumbs up button down there. And if you enjoy these Hangouts and want to know more about videos that are released to this channel, richardlawoffices.tv, then be sure to subscribe to the channel. And you get notices in your email box or whenever there's anything new. So that's it for August, and I'll see you after Labor Day on September 22nd to talk about what you need to do to put your will and estate plan together. See you then.